your submissions, please.
Yes, my lord. We adopt the claimant's written final address.
Yes.
Most respectfully, urge your lordship to grant the relief sought in their entirety.
Yes.
My lord, the oral submission made by learned counsel to the defendant ought to be contained in a reply to the claimant's written final address. Which the defendant did not file.
Yes.
There is nothing before your lordship in form of any reply concerning section 84 of the Evidence Act 2011.
Yes.
As it relates to exhibit C6, my lord.
Yes.
However, my lord, we most humbly commend the decision of the Court of Appeal, Lagos Division, to my lord.
Yes.
On the exceptions to the rule learned counsel for the defendant seek to rely on.
Yes.
That such certificate is not required.
Yes.
Where the party that has tendered such electronically generated evidence is not in control. My lord, that is the case of Stanbic Bank PLC. Stanbic Bank PLC.
Yes.
Versus Long-Term Global Capital Limited. Long-Term Global Capital Limited and others. Unreported decision, appeal number CA, my lord.
Do you commit that decision to the court then, because you said it's unreported?
We will forward the certified report.
Okay, Stanbic Bank PLC versus Long-Term Capital.
Long-Term Global Capital Limited. Global Capital Limited.
Yes.
And others.
Yes.
The decision of the Court of Appeal Lagos Division in appeal number CA.
Yes.
/L.
Yes.
/1093.
Yes.
/2017.
Yes, thank you.
Particularly pages 8 to 71.
Delivered when?
Delivered, my lord, on the 17th of September 2017, my lord.
What date?
17th September 2017, my lord.
It should be reported by now.
Yes, my lord. We will ensure that we forward the reported version.
Okay, thank you.
We urge my lord to discontinue the submission against the months. May it your lordship.
The case of asked to John Batchelor. Accountant in Abuja. But I think we have his phone number. Just call him to send, ask him to send the account. And we'll come back to you.
Court cases adjourned to.
Well, no, the chief.
Whoever is using Uwai and is listening to me now should please mute the phone. Case is adjourned to the 7th of December 2022 for judgment.
Most obliged.
Yes, the next case, please.
Case number 2,
Yes, call the next case.
Case number 2, NICS/2022. Polytechnic and 7 others. The claimant is present.
Sorry, please, we are not getting the registrar.
I don't know what's happening at their end. Who is calling the case, please?
Case number 2. Case number 2, NICN/KD/09/2022 between Professor Mohammed Sani Yahya and the Registrar Kaduna Polytechnic and 7 others. Hello, the claimant is present. Dependent absent.
Claimants present.
Yes, my
Defendants
lord.
absent. Yes, appearances, please.
Yes, respectfully, my lord. My name is Jabil Suleiman.
Yes.
My humble representation is for, oh, sorry, my lord, I on the behalf of Al Zubair Abubakar Esquire.
Sorry, I can't hear you. Yes, you said J. Suleiman for who?
Yes, Jabil Suleiman. I hold the behalf of Al Zubair Abubakar Esquire
Yes.
for the claimant's respondent, my lord.
Yes.
May it please the Honorable Court. My name is A. Isaac.
Yes.
My humble appearance is for the first, second, third, and 7th defendants. First, second, third, and 7th defendants.
Yes.
You know,
We
I
propose
also hold the,
Yes.
I hold the brief of M.N. Mohammed Esquire for the 6th and 7th defendant, my lord, equal to 7.
For who? 6th and who?
M.N. Mohammed,
Yes.
6th and 7th defendants, my lord.
6th and 7th?
Yes, my lord. That is for the
Why-
permanent secretary, Federal Ministry of Education.
But you
And-
just announced yourself for 7th now. Did you notice that you said you are for the 1st, 2nd, 3rd, and 7th, and yet you're still holding brief for 6th and 7th?
Oh, pardon me, my lord. I am for the 1st, 2nd, 3rd, 4th, and 8th defendant. I'm so sorry.
So now 1st, 2nd, 3rd, and 8th?
8th defendant, my lord.
Yes, thank you. So you're
Thank-
holding, the person you're holding brief is for the 6th and 7th.
Yes, my lord. I'm so sorry.
Yes.
Lord, Learned Counsel for the 6th and 7th has 2 motions on notice.
Yes.
We profile unity. I've not announced. We profile unity this court. Al Amin Abubakar.
Yes.
For the 4th defendant.
Yes. No representation for 5th. Yes, Mr. Ishak, you can proceed with your motions. Which motions are you talking about?
Thank you, my lord. They are dated, the motion were filed on the 7th of September 2022, my lord.
What are the motions about?
The first motion is seeking for enlargement of time to file counter affidavit in opposition to the motion of notice dated 7th March 2022. The second is also seeking for enlargement of time to file memorandum of appearance and counter affidavits in opposition to the originating summons dated 7th March 2022.
So motion, why did he break the 2 motions? Couldn't the 2 come together?
Yes, my lord, the claimant has 2 processes. He has an application for injunction before you, and he also has the originating summons.
What I'm saying that both motions are they not both for extension of time?
Yes, my lord.
Couldn't it have been paragraphed in one motion and just go with it? So motion for extension of time to file counter affidavit, then motion for extension of time to file memo.
And counter affidavit to the originating summons.
What was the first one for? It was enough for counter affidavit too.
Counter affidavit to motion on notice for interlocutory injunction.
Counter affidavit to motion on notice.
For interlocutory injunction, my lord.
Yes, and the other one is counter affidavit to the originating summons. When were they filed? Were they filed on the same day?
Yes, my lord. They were filed the same day.
What date?
7th September 2022.
I believe the motions have been served on parties.
Yes, we have been served, and we do not intend to object. Court defendants.
Okay. Claimant, have you been served?
Yes, my lord, we have been served with their motions, my lord, with their applications.
My lord, in the circumstance, we move in terms and respectfully us we love to grant the applications. We are most obliged.
Court's application granted. Time is hereby enlarged in which the 6th and 7th defendants may file the following processes. 1, memo of appearance. 2, counter affidavits to the originating summons. 3, counter affidavits to the interlocutory injunction. The already filed and served processes are deemed as properly filed and served.
Please, God, please.
We are most obliged.
Yes.
Yes, my lord. The matter supposed to come out for our applications, my lord. However, my lord, we have just been served with.
Sorry, I didn't hear that part.
Yes, my lord. The matter ordinarily comes up for our applications, my lord. However, my lord, we have just been served with the 6th and 7th defendants counter affidavits.
Yes.
Which we intend to respond, my lord. And in the circumstance, my lord, we shall be asking for another date to respond to same, my lord. We are most obliged.
No objection to the application for adjournment?
No objection, my lord.
We are actually not objecting.
Persons adjourned to the 23rd of November, 2022 for hearing.
Yes, my lord. We just intend to draw my lord's attention on.
So what is that?
Yes, my lord, the sixth, oh sorry, my lord, the seventh respondent defendant, my lord, just issued an appointment letter to the rector, my lord, Kaduna Polytechnic, which our interlocutory, which our application for interlocutory injunction seeks to cure, my lord.
Yes.
That's what I'm saying. We just want to draw the attention of this honorable court to inform my lord what is on ground now, my lord. There's a pending application that seeks to cure that, and they still move ahead to issue an appointment letter to the rector, my lord. We are most grateful.
Yeah, thank you. Well, you ought to have filed a process in that regard, because I do not know what you want me to base the, maybe you have to file something in that regard so that it will be on record of the court.
As the court pleases.
Thank you.
I'm most grateful.
Court cases adjourned to the 11th of November 2022 for hearing. Hearing notice to be issued and served on the fifth defendant. Yes. The next case, please.
Case number 3, NICM/ABJ/216/2016 between Omar Jube Okara and 1 Federal College of Education, Zaria, 2 Provost, Federal College of Education, Zaria, and 3 Registrar, Federal College of Education, Zaria. And all parties absent.
Yes, appearances, please.
May my noble lord be pleased.
Yes.
Nasser Saidu.
Yes.
My humble appearance is for the claimant, my lord.
Yes. Any representation for defense? I thought I saw Mr. Adekunle in a while before the courts began sitting.
Yes, he's online, but he muted his microphone.
He's online, but he muted his microphone. Mr. Adekunle, can you unmute your microphone and announce your appearance?
Yes, my lord. With
yes.
Profound humility to my noble lord. My name is Yemi S. Adekunle.
Yes.
I most humbly appear for all the defendants. I'm most grateful, my lord.
Thank you. Judgment. As a starting point, I should state that this judgment was initially slated for the 29th of September 2022, but the court was still on annual vacation as at that date and was further adjourned till today. The claimant was an assistant executive officer of the first defendant until he was suspended. In a nutshell, the claimant was alleged to have instigated students to protest against the first defendant for scarcity of water in the hostel, increment of tuition, and the closure of the registration portal. The claimant's grounds against the defendant is that the procedure stipulated in the conditions of service for the issuance of a query was not complied with, and further contends that the disciplinary committee set up to investigate the allegations leveled against him was fraughted with irregularities. The claimant alleged that his suspension from the first defendant is illegal, null and void, as same is in breach of the first defendant's condition of service and public service rule 2008. On the basis of this essential facts, claimants took out a complaint and statement of facts against the defendant in this court on the 17th of June 2016, whereby he claimed against the defendant the reliefs set out as follows. The reliefs are stated on the face of the judgment, 10 reliefs. Not to waste the time of the court, I've skipped the reliefs. It's on the face, you can always read that out. In the statement of defense deemed filed on the 9th of May 2017, the defendant admitted that a query was issued on the claimant based on the allegation leveled against him, and that he was subsequently suspended by the disciplinary committee that investigated him. The defendant, however, denied that the process of the issuance of the claimant's query and his subsequent suspension was illegal. The defendants further contend that the claimant did not wait for the outcome of the investigation of the disciplinary committee before instituting the present case, and as such, the action is premature. The claimant subsequently, on the 17th of May 2017, filed a reply to the defendant's statement of defense. At the plenary trial, the claimant testified in person and called no witness. He adopted a statement on oath as his evidence in chief and further tendered a total of 9 sets of documents in evidence as exhibits. He was duly subjected to cross-examination by the defendant's learned counsel. For the defendants, one, Ame Upa, a member of staff of the first defendant, testified on her behalf. He equally adopted the statement on oath as his evidence in chief and tendered no document in support of the defendant's defense. He was in turn cross-examined by the claimant's learned counsel. At the conclusion of plenary trial, parties filed and exchanged their final written addresses in the manner prescribed by the rules of this court. In the final address filed on behalf of the defendants on the 23rd of June 2022, Yemi S. Adekunle Esquire of counsel formulated the sole issue as having a reason for resolution in the suit, that is, I quote, whether the claimant is not hasty without allowing a course of action to accrue before rushing to court, end of quote. In turn, the claimant, through his learned counsel, Nasir Sahidu Esquire, filed his final address also on 23rd of June 2022, wherein 3 issues are identified as having a reason for determination in the suit, namely, 1, whether having regards to the totality of the evidence before this court, both oral and documentary, the defendant had proved that the claimant had instigated students to protest for lack of water in the hostel and closure of students' registration portal to warrant issuing the query and suspension letter against the claimant. 2, whether by the extant provision of the first defendant's staff handbook dated October 1992, which provided for the disciplinary procedure and provisions of 1999 Constitution as amended, the claimant was not denied fair hearing. And 3, whether the claimant is entitled to claim damages and restatement against the defendants. Upon a careful appraisal of the totality of the pleadings of parties, particularly the facts in issue in dispute, the evidence laid on the record, including the documents admitted as exhibits, and flowing also from the issues submitted for determination by respective learned counsel and the totality of the written submissions, I am of the view that the focal issues arising for resolution in this suit can be succinctly distilled as follows. 1, whether having regards to the conjunction of circumstances and the events in this case, the suspension of the claimant from the employment of the first defendant was unlawful. 2, upon resolution of issue 1, whether the claimant established his entitlements to reliefs claimed in the suit against the defendants. In proceeding to determine those issues, I state that I had also carefully considered the totality of the submissions conversed by the parties, learned counsel in their respective written final addresses, which was adopted on the 23rd of June 2022. I shall endeavor to make specific reference to learned counsel's arguments as it is considered needful in the course of this judgment. It is a settled principle of law that in a civil case, the burden of proof lies on the person who desires the courts to give judgment as to any legal right or liability, which depends on facts which he has sought to prove that those facts exist. It is also settled that the burden of proof in a particular proceedings lies on the person who will fail if no further evidence is given on either side. See sections 131 and 132 of Evidence Act 2011, where a party adduces sufficient evidence to satisfy the court that the fact sought to be proved is established. The burden shifts to the person against whom judgment will be given if no further evidence were adduced. The burden of proof will then continue to shift until all the issues in the pleadings have been dealt with. See again, section 133 of the Evidence Act. It is equally settled that the standard of proof in civil cases is on the balance of probabilities. See the cases of Wulechem versus Kudu, AG Bayelsa State versus AG River State, Agbakuba versus INEC and others. Citations also applied. From the evidence on records, parties are added in that the claimant was employed by the first defendant. It is also not in dispute that a query was issued against the claimant on allegation that he instigated students in the hostel of the first defendant to demonstrate for scarcity of water, increment of tuition, and closure of the registration portal. The letter of offer of appointments, confirmation of appointments, letters of promotion, letter of change of cadre, and query were respectively admitted in evidence as exhibits C1, C2, C3, C3A, C4, and C5. The grounds of the claimant against the defendant is that the issuance of his query, the procedure adopted by a disciplinary committee that investigated the allegations leveled against him as a suspension were not in accordance with the provisions of his conditions of service and the public service rule. The testimony of the claimant is that on the 5th of May 2015, he received a query purportedly based on a security report that he was not invited by the security panel that allegedly prepared the security report, or was he availed of the said security report before the query was issued, and that his superior, one Mrs. Miriam Alidu, did not give an opportunity of being heard before issuing the query. The claimant testified that at 9:30 of 7th of May 2015, he received a letter of invitation to appear before the Junior Staff Disciplinary Committee, JSDC, scheduled to hold at 10 a.m. of the same date, that contrary to the first defendant's condition of service, the members of the JSDC were constituted from academic board and that he was served with a letter of suspension shortly after the sitting of the committee. The letter of invitation to appear before the JSDC and letter of suspension were tendered in evidence as exhibits C7 and C8 respectively. The first defendant's condition of service was also admitted in evidence as exhibit C6. The claimant alleged that the disciplinary procedure that resulted in suspension was not in compliance with the principle of fair hearing, that in violation of the public service rules, the head of his department was also a member of the investigating committee, and also in clear violation of first defendant's condition of service, he has been on suspension for more than 3 months. The claimant testified further that his monthly salary is 35,918 naira 50 kobo, that while on suspension from May 2015 to March 2016, he was paid less than half his salary, that he has not been paid any salary since March 2016 till date of filing this action, and that as a result of his suspension, he has been subjected to psychological anguish, discomfort, and inconvenience. Now, paragraph 2 of exhibit C1, the claimant's letter of offer of appointments makes it clear that his appointment is governed by the general conditions of service applicable to his grade. It is therefore firmly established that the material period, the claimant's employment with the first defendant is statutory. In other words, the claimant's employment was one with statutory flavor, conferring him with a legal status higher than an ordinary master-servant relationship, and could only be disciplined in the way and manner prescribed by the statute establishing the first defendant or the regulation made under it. DW1, who testified as the sole witness of the defendant, was the secretary of the committee that investigated.
My Lord, I'm sorry for the obstruction. I am not hearing you.
I'm also not hearing.
Okay, so the problem is from my Lord.
I'm so sorry. Please, can we just exercise?
I don't know whether the registry will draw her attention.
I'm sure they are working on it.
Hello?
Hello, I'm sure they are working on it. Thank you very much.
Okay, okay. Thank you.
Is the disconnection from me or from the from the headquarters?
My Lord is from you.
Yeah, I'll continue. So I'm connected now. So I'll take it from paragraph 13.
Again, I'm not hearing. Mr. Emi.
I think it's from the host. I can't hear you.
Okay. I hope the registry are there.
She'll be back shortly, please. Connection. She'll be back shortly, please. Thank you.
Yes, can you hear me now?
I can hear you, my Lord. I can hear you now.
Yes, thank you. Sorry, we have to deal with these things. I am on like 3 networks, but yet they are still failing. So paragraph 13, DW1, who testified as the sole witness of the defendants, was the secretary of the committee that investigated the allegations against the claimants. His testimony is that the defendants got a security report of impending protest of students who had allegedly been instigated by the claimants over imposition of late registration fees. DW1 confirmed that after the claimant was issued a query and invited to appear before the committee to defend himself and was thereafter suspended by the committee, DW1 maintained that, but for the prompt suspension of the claimants, there would have been a very violent protest by the students on the 18th of May, 2015. On the basis of the foregoing, therefore, the focal controversy between the parties is clearly understood, being the procedure adopted by the defendants in the suspension of the claimants. In other words, the crux of the claimant's case and upon which the determination of his claim turns is whether the defendants breached the procedure prescribed by the first defendant's condition of service and the PSR for his suspension, particularly on the alleged violation of his right to fair hearing. To be unlawful, there must be proved that there is a departure from the prescribed procedure, or that in applying the rule, there is a violation of the rule of natural justice, so as to render the formal compliance a travesty. See the cases of Nwochukwu versus Nwuzu, Nigeria Gas Company Limited versus Judiciala, WAEC, and others versus Ikong. Citation all supplied. For proper appreciation and considering the relevance of Exhibit C6, the condition of service, I take liberty to reproduce the essential portions of Chapter 6 thereof relating to disciplinary procedure and the suspension of junior staff as follows. 6.12 junior staff. 1. If any junior staff is accused of misconduct or inefficiency, the provost may suspend him for not more than 3 months, and otherwise shall direct the junior appointments and promotion committee, A, to consider the case, B, to make recommendations as the appropriate action to be taken by the provost, and 2, in all cases under this section, the officer shall be informed of the charge against him and shall be given reasonable opportunity to defend himself. I had undertaken a scrupulous review of the evidence proffered by the contending parties. The pertinent question is whether the defendant afforded the claimant the reasonable opportunity to defend himself before he was suspended. The allegation leveled against the claimant in Exhibit C5 was based on the security report, but the claimant testified the same was not made available to him for his defense. The further testimony of the claimant is that he received the letter of invitation, Exhibit C7, at 9:30 of 7th of May 2015, and that the sitting of the disciplinary committee was scheduled at 10 a.m. of the same day, and as such was not given reasonable opportunity to defend himself. The letter of suspension, Exhibit C8, was also issued on the same day. Now, it is settled that facts averred in pleadings must be substantiated and proved by evidence. This is because pleadings have no mouth to speak in court, and so they speak through witness. Therefore, pleadings must be proved by evidence, failure of which it goes to nothing, as pleadings do not take the place of evidence. See the cases of Oluyede versus Access Bank PLC, TGG and Nigeria Limited versus Toweshi, citation supplied. Applying this to the instant case, the claimant had pleaded and proved by documentary evidence that he was not given reasonable opportunity by the defendants to defend himself. The defense put forward by the defendants in the statement of defense is that verbal warning had been issued on the claimant, that the claimant instigated the students to protest for scarcity of water in the hostel, and that the claimant was issued query based on the security report that the planned protest was scheduled on the 8th of May 2015. The claimant was subsequently suspended by the disciplinary committee. Going through the evidence on record, the averment of the purported security report against the claimant and the alleged instigation of students by the claimant were not supported by the evidence of DW1, who was the secretary of the disciplinary committee. The report of the committee was also not tendered by the defendant to debunk the claimant's evidence that he was not afforded reasonable opportunity to defend himself. I should remark that contrary to the submission of learned counsel to the defendants, the burden of proof had shifted to the defendants, which they had failed to discharge. I cannot but agree with the submission of claimant's learned counsel that the claimant was not given reasonable opportunity to defend himself as prescribed by the conditions of service of the first defendant. The disciplinary procedure adopted by the defendants for the suspension of the claimant is therefore unlawful, and I so hold. The further contention of the claimant is that the defendants breached the prescribed procedure in the conditions of service on his suspension. In paragraphs 27 and 28 of the statement on oath, the claimant testified that he had been on suspension for more than 3 months and that he has been paid less half of the salary from May 2015 till May 2016, when his salary was stopped. Perhaps I should remark at this point that it is in accord with judicial decisions and business practice to suspend an officer being investigated from the place of work, to permit unhindered investigation to be carried out, and also to allow peace to reign at his place of work pending the final determination of his involvement in the accusation. The suspension must, however, be in accordance with the guidelines, rules, and law of the employer. Now, it is clearly stated in section 612, sub 1, reproduced above, that the provost may suspend a junior staff accused of misconduct as the claimant in the instant case for not more than 3 months. The word suspension is also defined in chapter 1, section G42 of the exhibit 6 to mean I quote, temporary removal of a staff from duty resulting from misconduct. Such removal from office shall be for a period not exceeding 3 months and shall be with half pay. End of quote. I have also considered the arguments of learned counsel for the defendants that the claimant was suspended to enable proper investigation into the allegation leveled against him, but rather than waiting for the outcome of the investigation, the claimant hastily instituted this action. The clear evidence on record is that the claimant has been on suspension for a year before instituting this case. In my modest opinion, what I see here is that the learned defendants counsel is clinging to any straw to support the case in order to cover up for the failure of the defendants to comply with the provision of Exhibit C6 in relation to the fixed duration of period of suspension of 3 months. In the instance case, my view is that the defendants not only unlawfully issued a letter of suspension of the claimant, but they also acted contrary to the clear provisions of the condition of service as set out in Exhibit C6 by failing to consider the claimant's case and make recommendation as to the appropriate action to be taken by the provost within 3 months of his purported suspension. And I so hold on his claim for reinstatement and arrears of salaries, having held that the suspension of the claimant as unlawfully strides and as correctly submitted by claimant's learned counsel, that one suspension or termination or dismissal of an employee is declared as unlawful, the employee must be reinstated. There are legions of cases on this settled principle. The claimant is therefore entitled to his claim for reinstatement and his arrears of salary. I so further hold. I now proceed to the claim for damages. Having held that the claimant's suspension was unlawful, it follows that the claimant, as a general rule, is ordinarily entitled to damages for the action of the defendants. The law is well settled that in breach of contract cases, there is no distinction and dichotomy as between special or general damages. The applicable principle is simply that where two parties have made contracts, which one of them has broken, the damages which the other ought to receive in respect of such a breach of contract should be such as may fairly and reasonable be considered, either arising naturally according to usual course of things from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. See the cases of DHL International Nigeria Limited versus Chidi, Nigerian Breweries PLC versus Adetong Olajide, citation supplied. The claimant's testimony is that he was placed on half salary and subsequently the defendant stopped paying the salary. He also testified that he had suffered psychological pain and untold hardship by his unlawful suspension by the defendants. I must hold that the claimant has clearly established his entitlements to the declaratory reliefs and for damages by credible and unassailable evidence. On the whole, the claimant's action succeeds against the defendants. I hereby order as follows. 1, it is hereby declared that the suspension of the claimant by the first defendant's letter of suspension dated the 7th of May 2015 is unlawful, null and void, and same is accordingly set aside. 2, the defendants are hereby ordered to reinstate the claimant forthwith. 3, the defendants shall pay to the claimant the total of 2,900,000. I hope I'm still being heard.
No, my lord.
My lord, I didn't hear the last.
I can hear you now.
Okay, I'm on 3 now. The defendant shall pay to the claimant the total of 2,945,317 naira, only being his salary for the date of a suspension as follows. A, the sum of 179,592.50, 175 595,592 naira 50 kobo of 17,959.25 from May 2015 to March 2016. B, the sum of 2,765,724 naira 50 kobo, being monthly salary of 35,918 naira 50 kobo from April 2016 till date. I hope that is clear. I just broke down the total of 2,945,317 in two parts. One part is for the half salary that was unpaid. Then the other part is from the full salary from now for a sum of 500,000 naira only is awarded against the defendant as damages. It is hereby further ordered that the defendants shall pay the sum set out in 3 and 4 above within 30 days to the claimants, and thereafter at the rate of 10% per annum from the date of those judgments until the same is finally liquidated. Parties shall bear their respective costs. Yes, that is the judgment of the court.
My Lord, we are very much grateful for the well-considered judgment. We pray Almighty Allah to continue to guide you in the course of your dispensation of justice, my Lord. We thank you very much, my Lord.
Thank you.
Yes. So I'm especially grateful to my noble Lord for his time, pain, and all that taking in writing this erudite decision of my Lord. We have always stated that your Lordship has been honored.
Yes, can we call the next case, please? Thank you for your compliments, Mr. Adekunle. Well received. God will continue to guide us all in the temple of justice. Thank you. Yes? The next case, please.
Case number 4.
Yeah, sorry, the judgment will be ready by Tuesday, please. I understand there's public audio on Monday, so I will send it over by Tuesday. You can pick it up. Thank you. Yes, the next case.
Case number 4, NICS/KD/09/2019 between Nigeria Defense Academy and 1 Mrs. Sepinatu Ali Dogo and 2 Dr. Subelu Oche Abdulrahman. My Lord, parties absent.
Appearances, please.
May it please my noble Lord.
Yes.
May it please my noble Lord. Makwa Menuba. My appearance is for the claimant, my Lord.
Yes.
Respectfully, my Lord, R.I. Abdullahi for the second defendant.
No representation for first defendant. Yes, thank you, judgment. I hope this network will not disrupt this judgment. Okay, let's run.
I was unfortunately locked out earlier. Thank you very much, my Lord.
Yes, thank you. The claimant is a military tertiary institution established by statutes to train military cadets and award degrees as prescribed by the National University Commission. As gleaned from the claims before the court sometime in 2012, the claimants granted the application of the first defendant for sponsorship of a doctorate degree and approved a study leave with full entitlements. One of the conditions for the release of the sponsorship funds as agreed by the parties in the bond or agreement is that the first defendant will serve the claimant upon conclusion of the doctorate program. The claimant contends that the first defendant refused to return as agreed to train after the completion of a program and that appointment was subsequently terminated on the recommendation of its disciplinary committee for breach of the terms. The claimants alleged that the refusal of the first defendant to return created a vacuum in the institution, which resulted in grave deficiency in the training of cadets, and further alleged that the first defendant failed to refund the money expended for our sponsorship and for our salaries or allowances for the period of a program. The claimants further contend that as the surety of the first defendant, the second defendant is liable to refund the amounts being claimed. Based on the above summarized facts, the claimants commenced the instance action via complaint and statement of facts filed on this court on the 21st of February 2019, whereby it claimed against the defendants jointly and severally the reliefs set out as follows. The reliefs is as set out on the face of the judgment. I skip so not to waste the time of court. The first defendant did not participate in the proceedings throughout, even though the records of the court bear out that the originating processes and hearing notices for the scheduled dates, hearing dates were duly served on her. The second defendant joined issues with the claimant by filing a statement of defense deemed filed on the 15th of October 2019. The second defendant contends in summary that the guarantee made was for the sponsorship of the first defendant for an admission in University of Exeter, United Kingdom in 2012. The second defendant further contends that the first defendant procured another letter of admission in September 2013 and that his guarantee for the first defendant's admission was not utilized. The second defendant also contends that the bond he executed on behalf of the first defendant had elapsed or replaced by another bond executed by Associate Professor Ayuba Kwasiu and late Toyin Bakari as sureties of the first defendant. Perhaps I should note that this judgment was initially stated for 22nd of September 2022, but as at that date, the court was still on annual vacation and was further adjourned till today. At the plenary trial, one Mrs. Temitokpa Imam Abdulkadir, the principal assistant registrar of the claimants, testified as a sole witness. She adopted a statement on oath and as her oral testimony and further tendered 4 sets of documents as exhibits to further substantiate the claimant's case. She was thereafter cross-examined by the second defendant's learned counsel. In turn, the second defendant testified by himself as DW1 and was further subject to cross-examination by claimant's learned counsel. A subpoenaed witness, one Professor D.O. Alabi, testified as DW2. A total of 10 documents were tendered between both witnesses as exhibits. Upon completion of plenary trial, parties filed and exchanged their written final addresses in the manner prescribed by the rules of this court. In the second defendant's final address, deemed filed on the 22nd of June 2019, that cannot be correct. I'll check and revert. On the 22nd of June 2022, it should be. 2 issues were formulated for determination in the suit by I. Abdullah Esquire of Counsel, namely 1, whether the claimant has proved its claim on the balance of probabilities to warrant the grant of the relief sought against the second defendant whose guarantee has been overtaken by event. 2, whether the second defendant's guarantee signed in 2012 is still valid and subsisting to be liable, regard being heard to a subsequent bond signed in 2013. In the final address filed on behalf of the claimant, deemed filed on the 22nd of June 2022, as learned counsel Makwa A. Manuba Esquire also identified 2 issues as having arisen for determination in the suit, namely whether the claimant have on the preponderance of evidence and balance of probabilities prove its case to be entitled to the judgment of this court. 2, whether the second defendant's suretyship signed in 2012 is still valid and subsisting for him to be liable, regard being had to the subsequent agreement signed in 2013. Upon a proper appreciation of pleadings of parties, the totality of admissible evidence adduced in record, and the totality of circumstances of this case, it is my considered view that the narrow issue that called for a determination in this suit, without prejudice to the issues already formulated by learned counsel on either side, can be succinctly formulated as follows. I quote, whether having regards to all circumstances of the facts, evidence admissible in this case, this is an appropriate case for the exercise of court's judgment in favor of the claimant for the reliefs claimed in the suit. In determining this issue, I had carefully considered the totality of arguments canvassed by claimant and learned counsel for the second defendant in their written addresses and their oral adumbrations. I shall endeavor to make specific reference to their arguments as I deem needful in the course of this judgment. The case of the claimant has gleaned from the claims from the court before the court is that an application for sponsorship of the second defendant's training for doctorate degree, PhD, in political science / defense studies was approved by the claimant, that a bond agreement was executed by both parties, that one Mrs. Toyin Bakari, now deceased, and the second defendant were guarantors of the first defendant, and that one of the conditions as agreed in the bond is that after the completion of the first defendant's program, she will return to serve the claimant. The approved funds in the sum of 23,817,000 naira was released to the first defendant. The claimants alleged that upon completion of the first defendant's program in 2017, she refused to return to serve the claimant as agreed, and the disciplinary committee that investigated the allegation of a breach of contract made recommendation for the termination of her appointment. The claimants averred that the first defendant wrote a letter conveying her willingness to refund all the funds expended on her training, but that she had failed to refund the money as she promised. The claimants further alleged that the sum of 14,097,912 naira 50 kobo was expended on the first defendant as salaries, allowances for the duration of 4 years she was on study leave. The claimants also alleged that the second defendant is liable as a guarantor for the breach of agreement and failure of the first defendant to refund the money expended for our sponsorship and for our salaries and allowances for the duration of the program. The following documents were admitted in evidence to buttress the claimant's case, namely, study leave agreement dated 20th of April 2012, Exhibit C1, report of SSDC on alleged case of breach of NDA regulation as Exhibit C2, letter of first defendants to claimants later dated 16th of July 2018 as Exhibit C3, letter of claimants to the defendants dated 19th of November 2018 as Exhibit C4. As I had earlier noted, the first defendant did not participate in the trial. On the part of the second defendant, there is no dispute that the claimants granted the approval of the sponsorship of the first defendant for PhD program and that a bond was executed by parties. The contention of second defendant, however, is that his status as the first defendant guarantor elapsed when she did not leave the country for the studies as scheduled in 2012. The second defendant contends further that the documents tendered by DW2, the subpoenaed witness, disclosed that the first defendant has executed another bond agreement with the claimant in 2013 and that she returned to serve the claimant after her program. The second defendant denied liability to the claimant's claim. To further support his case, the second defendant tendered in evidence a copy of the study leave agreement dated the 29th of June 2013 as Exhibit D1, application to access the first defendant's personal file dated the 17th of June 2019 as Exhibit D2, application and 9th of October 2012 as Exhibit D3 and D3A, letter of offer of admission to University of Exeter, Exhibit D4, 13, Exhibit D5, application for sponsorship dated 13th of February 2019, Exhibit D6, correspondences between the claimant and TET fund as Exhibit D7, D7A, and D7B, respectively. Now, as correctly submitted by Learning Counsel for the second defendant, the law is very trite to the effect that any party who desires a court to give judgment as regards to any legal rights or liability dependent upon any alleged existence of facts must prove that those facts do actually exist. See Section 131 of Evidence Act 2011. See also the case of Okoye versus Nwako and the case of UIC Limited versus Amond Nigeria Limited, citation supplied. The determination of the suit, in my view, will turn largely on the understanding of the purport of the obligation of the defendants, in particular with reference to the bond for the study fellowship. From evidence on record, it is stating the obvious to affirm from the onset the relationship between the claimant and the defendants is delimited by a bond agreement. The argument of Learned Counsel for the claimant is that the course of action against the defendants is for breach of agreement. Learned Counsel submitted further that parties are bound by the deed. Learned Counsel submitted further Learned Counsel okay. Thank you. I'll take that part again. The argument of Learned Counsel for the claimant is that the cause of action against the defendants is for breach of agreement. Learned Counsel submitted further that parties are bound by the terms of contracts. The failure by a party to the terms agreed will amount to a breach of contract, and the consequences of the breach is that damages to the aggrieved party. As a starting point, it is on record that the claimants and the first defendants executed two different bond agreements as conveyed in Exhibit C1 and D1/D5. From the totality of the evidence adduced on record and as recapitulated in the foregoing, it is clear that the issue as to the claimant's claim of breach of agreements cannot be fully resolved without a determination as to the operative bond agreements. This determination becomes imperative in that even though, as I noted in the foregoing, that the claimants maintained that the second defendant is liable as the guarantor of the bond agreements, Exhibit C1 executed in 2012, the second defendant, on the other hand, contended that the claimant had executed a new bond agreement, Exhibit D1/D5, with other guarantors in 2013, and as such, that he is no longer bound by any legal claim over the alleged breach of agreements of the second defendant. The testimony of the second defendant exonerating his liability as claimed under cross-examination by the Learned Claimants Counsel is as follows. I quote, "At the time she, that is the first defendant, brought the form in 2012, the scholarship was not granted. By July 2013, she applied for another scholarship and she had to look for another guarantor. That is Dr. Ayuba Kwasu and Dr. Mrs. Bakari, now late, signed the 2013 guarantor form. The scholarship was granted in 2013, end of quote. I had taken a calm examination of Exhibit C1, D1/D5, the documents executed by the parties. The bond agreements are dated 20th of April, 2012 and 29th of July, 2013. I note that the bonds have different guarantors. While Mrs. Toyin Bakari and Dr. Suberu Ochi Abdurrahman, that is the second defendant, are the guarantors of Exhibit C1. The guarantors of Exhibit D1, D5 are Mrs. Toyin Bakari and Dr. Ayuba Kwashu. Now, the overwhelming documentary evidence in Exhibit C2, C4, and D4, both by the claimant's sole witness and the second defendant and his witness, clearly established that the fund for the sponsorship of the first defendant was released to pursue a 4-year training in PhD, Philosophy in Politics, at the University of Exeter, United Kingdom, from August 2013 to July 2017. The payment of salary incurred on the first defendant was from August 2013 to November 2017. That from the offer of admission of the University of Exeter, the duration of the program was from 23rd September 2013 to 21st of September 2017. At this point, it is pertinent to remark that the claimant's learned counsel must have misapprehended the state of pleadings before the court, and in particular, the burden duty on the claimant to adduce cogent evidence to establish his claim that the second defendant is bound by the bond he executed as guarantor of the first defendant. When she argued severally that the second defendant failed to put the documents he relied on to prove that he has been discharged of being a guarantor with the execution of a new bond by another guarantor. Now, sections 131 and 133 of the Evidence Act 2011 stipulates that the claimant has the duty to lead evidence first in civil cases. Section 136 of the Evidence Act provides that the burden of proof as to any particular fact lies on that person who wishes the courts to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on a particular person. The burden may, in the course of a case, be shifted from one side to the other. These provisions of the Evidence Act has been considered by the courts in a plethora of authorities. See Onovo versus Mba, Ntuama versus Akbaime, Ezemba versus Ibeneme, citation also applied. It is clear from the above authorities and the plethora of authorities on burden of proof that in order to discover where the burden of proof lies in a civil case, the court has a duty to peruse the entire pleadings of both parties. It is also the consensus of the case authorities that in civil cases, the burden of proof initially lies on the claimant. In other words, in civil cases, the claimant has the initial burden to lead evidence to prove his assertion, but the burden of proof is not static. Once the claimant establishes a prima facie case, the burden of leading evidence in rebuttal shifts to the defendant and vice versa. I have considered the oral and documentary evidence by contending parties. The second defendant in denying his liability to the claimant as the guarantor of the first defendant, he tendered in evidence the new bond agreements, Exhibits D1, D5, executed by Mrs. Toyin Bakari and Dr. Ayuba Kwashu in 2013. The burden has therefore shifted to the claimant to prove that the second defendant is still liable under the previous bond executed in 2012. I believe the plausible testimony of the second defendant, which is supported by documentary evidence in Exhibit D1/D5, that is not the guarantor for the first defendant's sponsorship for a PhD program in 2013. I agree with the arguments of the second defendant's learned counsel on the basis of the totality of the unassailable evidence adduced by the second defendant that the claimant had executed a new bond agreement with new guarantors as clearly encapsulated in Exhibit D1/D5. This court is duty bound to construe the document on the basis of the clear intention expressed therein, which in simple terms is that the claimant executed the bond with the new guarantors, Mrs. Toyin Bakare and Dr. Ayuba Kwashu, and I still hold.
As a court leader.
The basis of the claimant's claim against the first defendant is that she breached the terms of the agreement by not returning to serve and thereby claimed for the refunds of the money expended for the program and salaries paid to her for the duration of the program. The first defendant did not defend the claim, but the law is settled that the claimant is duty bound to prove the claim. Now, admission means a voluntary acknowledgement made by a party of the existence of the truth of certain facts which are adverse to his claims in an action. An admission made on a pleading need no further proof, and a party admitting is stopped from denying it. There are too many cases on this principle. See the cases, see Section 123 of the Evidence Act, and see the cases of Akinlagu versus Oshobajo, Nigichin Industries Limited, and Ladende. Thus, admission is a question of facts. In deciding whether a party has indeed made an admission, the court has to consider the totality of pleadings of that party. Paragraphs in the pleadings should not be considered in isolation, but should be read together. Also, the admission in itself must be unequivocal. The averment in paragraph 8 of the statement of claim is that first defendant refused to return as agreed and thereby breached the term of agreement. It is true that the claimant had in paragraphs 12 and 13 of the statement of claim further averred, can I still be heard?
Yes.
Further averred that it did receive a letter, Exhibit C3, from first defendant through DHL Courier Services, conveying her willingness to refund the money expended on her for training, and that in a reply, that is Exhibit C4, was dispatched to her, but got no further reply from her. It is also true that the first defendant in Exhibit C3 categorically stated in paragraphs 3 and 5 thereof that on 13th November 2017, she reported to Mrs. Badmos, the Deputy Registrar, on resumption of duties with the claimant, and that she carried out the duties of invigilating examination and supervising through KDEC, and our willingness, as agreed in the bond, to refund the expenses incurred by the claimants for her study. Having regard, therefore, to the unequivocal admission in Exhibit 3 of our liability to the claimant and our willingness to come to an agreement with the claimant for the payment of the refund of the money, the first defendant, I must state that the claimant is entitled to the claims admitted by the first defendant, and I so hold.
As a court leader.
For refund of salary and allowances in the sum of 14,097,352.50 kobo paid to the first defendant for the duration of a program, I hold that the claim is for special damages, which must be specifically pleaded and proved strictly. The claimant failed to prove this claim by cogent evidence. In totality, I hold that the claimant's claim as meritorious in part for avoidance of doubts and abundance of clarity. Judgment is hereby entered in favor of the claimant in part against the first defendant upon the terms set out as follows. 1, the first defendant is hereby ordered to pay to the claimant the sum of 23,800,000 817,600 naira only, being the money expended by the claimant to the first defendant for a program at the University of Exeter, United Kingdom, between 2013 to 2017. It is hereby also ordered that the first defendant shall pay to the claimants the sum set out in one above within 30 days, and thereafter at the rate of 10% per annum. Parties shall bear their respective costs.
As the court pleases. We are most grateful, my lord, for your considered ruling.
Thank you, Mrs. Ibrahim.
Yes, my
It's
lord.
an appropriate place to congratulate you. Congratulations on the birth of your son. I hope he's doing well.
He is doing well, my lord.
Thank you. Yes, thank you. So the judgment will be ready by, oh, you're showing me. He was part of the proceedings, so he should listen to the judgments too.
Exactly, my lord.
Yes, he was part of the trial, carrying him about. So it's good that he's listening to the judgments too.
Yes, my lord.
Yes, my lord.
Thank you.
Thank
so
you.
So the judgment will be ready by Tuesday by God's grace. Thank you. The court will now rise.
Thank you, my lord.
Thank you.